Thank you. So it's my difficult task here to present you a 60-year experience of Romanian notary in delivering a document which is called Certificate of Succession. And we deliver this document both in national procedures and in international procedures. So I try to explain all the provisions of the regulation through my own practice and to make constantly a comparison between this European document and the certificate of succession we deliver in Romania. So I did find out we have created with this regulation a real competition between the national documents and this uniform document called European certificate, because of course the heirs in Romania are usually they go to a notary to solve the succession. So they will do so because they obtain a certificate of succession, which is a property title which provides for the heirs the quality of heirs and also for the assets included in the succession. This is why it is so difficult for us to accept that the future European certificate will not include the assets and will not provide a final settlement of the succession. And I found in the regulation some kind of the regulation is not determined whether to declare this certificate as a property title or not. It's a final settlement of the succession or not, because the regulation, when it speaks of court decisions, uses the terms like finally settle the succession, but when it speaks about the European certificate, says the issuing authority will certify some elements, maybe the applicant can provide the court which is currently solving the entire succession. So I'm not sure this European certificate of succession should or should not be a final settlement of the succession, which we do in the Romanian procedure. So first of all, what is the current situation in an international succession? If we take the case of a Romanian citizen, which has its habitual residence in Italy. So in Romania, currently we use the connecting factor of the last habitual residence, as the regulation does. But the Italian notary will use the connecting factor of citizenship. So through, if a Romanian notary is made recourse to in this succession, he will apply the Romanian law, but the Romanian law will make a renvoi to the Italian law, yes, which is the law of residence. Finally, the Italian law will renvoi back to the Romanian law as the law of citizenship, and finally the Romanian notary will apply the Romanian law. With the same reasonment, the Italian notary will end up applying the Italian law in this case. So, when we talk about the assets, immovable assets situated in Romania, we have recently come to an exclusive competence of registering the notarial acts in the land registry, as in France. So only an authentic Romanian act or a Romanian court decision can be registered in the land register. So for the Romanian assets, presently, an Italian deed in matters of succession cannot be registered in the land register. This is a very recent modification of the law. So for the immovable assets, only the Romanian notary will be competent to deliver a certificate in this present time. But what we'll do, what the regulation will do, will allow us to deliver this European form, the European certificate, which is declared in Article 69 a valid document for the inscription in the land registers. But here we have a little bit of conflict. No, you do not agree. Yes? Well, in my opinion, this certificate, if the land register requires supplemental conditions, it will not be permitted the registration. If the land register permits the inscription of any kind of documents, this will be done through the European Certificate of Succession. But in Romania, like I said, at this time being with the law in the present law, the European certificate will not be a valid title for the transfer of immovable rights, although Article 69 declares so. So let's see what it is and what is not the European Certificate of Succession. It will be simpler for me to just say the European certificate is a form, and we'll just fill out the forms and the applicant form, and so we'll proceed like that. But I do not wish that the European certificate will end up like the executory European title, and there are so few titles like this issued by the notaries. I hope this European certificate will be used in the procedures of international successions, because, you know, it is not mandatory to issue this kind of certificate. The parties can also use in their country or in a different country the national documents. So there is a competition between the national documents and this European Certificate of Succession. So the certificate is a uniform document. It has a value of proof. Yes, of course, it's not the value of an authentic act or a court decision, but the certificate is presumed to be accurate when it comes to the elements that are certified in his content. So it has a probative value, and it is a streamlined form. But I repeat, and I assume this affirmation, it does not reflect a definitive solution, because the procedure is not strong enough to do that. What is not the certificate of succession, I said, is not a veritable property title, and is not an authentic act, neither a court decision nor a judicial transaction. But it has advantages, of course. First of all, it's not a mandatory document, but it can be used in the state that issued the document. So it's not intended to be used only abroad, but in the state that issued the document. So in Italy, it will be used both in Italy and in Romania, for example, if the case it is. And another advantage is the direct circulation, because no certificate of conformity is required, and there are no grounds for non-recognition. So this European certificate will circulate among the member states freely, with no condition required. We will not apply the apostille. We will not legalize the European Certificate of Succession, and we will not have grounds for non-recognition. This is very important, because, as our colleagues told you today, an authentic act and a court decision, there are grounds of non-recognition, but not for the European certificate. Of course, the main disadvantage of the European Certificate of Succession is the lack of enforcement power. When we want to obtain, when the heirs want to obtain a document which will have the enforcement power, they will apply to a national document, an authentic act, of course. And another disadvantage is that the certificate does not enjoy the res judicata authority. So the certificate can be modified, can be withdrawn, can be suspended by the issuing authority and also by a court of law. So I might say that the national acts who compete with the European certificate have a clear advantage. And even though the certificate will circulate in Europe freely, it will be a less efficient instrument, in my opinion. So if we compare this certificate with the Romanian certificate delivered in successions, we cannot deliver a certificate but in non-litigation cases. We have to obtain the consent of all interested parties. We have to establish beyond proof there are no other legatees or inheritors entitled to the succession. We have to receive testimony under oath and verify all the elements in order to deliver this certificate of succession, which I see it's clearly not the case with the European Certificate of Succession. But there are so many things to be established before the issue of the European Certificate of Succession. We have to establish the applicable law. We have sometimes to establish the applicable law to the matrimonial regime because it's so closely connected with the succession. We have to establish the quotes that the heirs will receive. Maybe the way they decided to part the assets of the succession. So it's indicated in the regulation. It's for the future to decide if we will do so or not. But these are the provisions of the regulation, and sometime we will end to do so. I don't know. Well, about the jurisdiction rules, because this point wasn't touched today, which are the authorities, which authorities are competent to deliver the European certificate? So when a notary solves a succession by the way of his own national act, he is not obliged to obey any jurisdiction rule unless the notary exercises a judicial function. But when it comes to delivering an European certificate of succession, the notaries, if they are empowered to deliver the certificate, they have to obey the rules of jurisdiction provided by Article 4, 7, 10, and 11. So the first rule is the jurisdiction is to be of the issuing authority of the last habitual residence of the deceased. This is a general rule. But in Article 7, the competence can be granted to another authority if the deceased have chosen the law applicable to its succession. The heirs can accept this choice and ask the notary of that country to deliver the certificate. So, first of all, general rule, the country of the last habitual residence, then maybe the authorities of the state of which the deceased have chosen the applicable law. The third case is when the courts of the location of some assets, if the deceased had not the last habitual residence in a member state and with a few conditions to comply. And the last one, if the authorities of the member states cannot, if the authorities of the member states are not competent throughout these former three situations, they still can handle the succession in the case in which other countries, other courts are not reasonable to do so. Yes. About the issuing procedure. So first of all, we have the interested party, which formulates a request. This will be done by a uniform form, which will be provided by the committees. And the circle of applicants is very strictly determined. The creditors, for example, in Romania, a person who has a title as creditor, he can also ask for a certificate of succession because, of course, he is interested in establishing the heirs and the person who will pay the obligation. But the regulation declared that a creditor is not entitled to ask for this certificate. So only heirs, legatees, administrators, and executors of will can apply for the issue of the certificate. Second of all, the applicant will deliver some proof, yes? It will be delivered in like document proof, as certified copies or in original, and I strongly advise my colleagues to use the power of discharging for this document proof wisely, because the regulation says, I quote, if the original or the copy of the document cannot be provided by the applicant, the authority has the power to discharge the applicant and use another form of proof. But this, I think this will not be used for the death certificate and another civil status documents, which are clearly compulsory to be used. The next step is the verification of information. Well, first of all, the issuing authority will verify that is competent throughout the Articles 4, 7, 10, and 11. The second step, I suppose, I advise the colleagues to do so, is to verify if the procedure is not lodged in another member state. And I hope this will be done through a unique evidence of international successions instated in the European Union, because it will be very difficult to prevent the ill use of this certificate, because the heirs can one day go to an Italian notary and ask for a certificate, and the Italian notary will find himself competent through Article 4, for example, and then go to Romania and ask the issue of the certificate invoking Article 7. So we will have two different certificates with the different heirs maybe, and we are definitely not wanting to end up like this. So unique evidence of these cases will be recommended.
I'm sorry, in these cases, what happens? I mean, even in the case of the second, of the 21 number 2, the exceptional case in which not the domicile but other circumstances are determining the law. What happens?
Well, of course, it will be a court of law to decide which document is the one issued with the perfect competence and which one will have effects. So if we go on with this verification of information, of course, the issuing authority will obtain all the necessary proof. It's stated in the regulation that the authorities will have direct access to the registers of another member state. I suppose that this will be done in some years, but not quite in the present. And a very delicate question. It is possible for the issuing authority to deliver the certificate and even not having the full consent of all the beneficiaries, because the regulation says I quote, "It is necessary for the authority to inform beneficiaries or other interested parties." So it is enough just to inform the heirs, the possible heirs. If we take the case that the heirs are in different countries, how the authority will make the public annunciations necessary? Well, in Romania, if we do not know the residence of a person, in cases of succession, we have to name a curator among the lawyers, which will will represent the interest of the person who is not fully subpoenaed. So, is the issuing authority able to deliver, I raised this question, to deliver the certificate only by informing the beneficiaries, or it is compulsory to obtain the consent of all the persons which have an interest in this succession? I think it's not possible to deliver the certificate because the regulation says in cases of challenge of any element included in the certificate, the issuing authority will stop the procedure and will not deliver the certificate. Oh, there are so many aspects, and we have some the lunch is coming. I will briefly well, the question that our colleague raised the eyebrows, if the certificate is a valid title for the entering of the property right into the land registers. So this is a difficult question to pose. And I repeat Article 69.5, I quote, "The certificate shall constitute a valid document for the recording of succession property in the relevant register of a member state, without prejudice to points K and L of Article 1. So, and also Recital 71 declares whether or not such a document, such an acquisition of property by a third person is effective should not be determined by the regulation. So the regulation has not decided, has not answered the question. Yes, it is the certificate a valid title for the registration or not?
No.
No. Yes, but Article 69.5 declares to be, yes. No, I agree with you, but also I am confronted with this text which declares something and then another text which declares another thing. So we have a question to ask. Well, I also have this answer that the certificate will not be able to be yes, registered in the land registers. So thank you for your attention. I have many information to give you, but I have the full presentation. Thank you.